after Houssein and others, London credit listed and others have had.
Mr. Wheeler, I'm sorry that took longer than we had hoped. We've lost a quarter of an hour. We'd be grateful if you would all therefore seek to be even more economical in your submissions than you were otherwise going to be.
I will be as economical as I possibly can be, my Lord, without omitting points that I need to make on my client's behalf, of course.
Yes.
It's a matter of substance. Perhaps just to finish off shortly the penalty point, perhaps I could invite the court just to go back to the judgment at page 130, the core bundle behind tab 9.1. And I just want to highlight one point arising out of paragraph 209 of the judgment. Because we see there, after his conclusion that the default rate was a penalty, he says that doesn't affect the normal rate of 1% per month. As I've noted, that was not challenged. But then he says, in any event, I accept that Mr. Theophanous gave proper consideration to LCL's legitimate interest in setting it, such that any challenge would not have succeeded. And in my submission, that reflects the judge's approach to this issue and demonstrates his error. He's asking whether LCL gave proper consideration to the legitimate interest in setting the rate, posing a subjective test, turning on the way the rate is rationalised in the specific circumstances of the loan. And that's not the test in Cavendish. The final point I need to make is the question of, well, if the judge had asked himself whether the default rate was extravagant, as I say he ought to have done, what conclusion should he have reached? In my conclusion, he should have reached the conclusion that it was not extravagant. And I deal with that at paragraph 23 of my skeleton argument, at page 58 of the core bundle, behind tab 4. If I could just make my selections, as it were, by reference to that, in order to save some time. Without repeating what I write there, but at paragraph 23.1, I make the point that the appellants were experienced and they were advised by solicitors. And the appellants say in response to that, well, they were under commercial pressure at the time this deal was done because they had another loan to refinance. One needs to understand that point in the context of the judge's finding at paragraph 79 of his judgment, which is at page 102 for your note. He found that the appellants had other options, and if they had thought that the terms that were being offered to them were not satisfactory, and this was in the context of Mrs. Houssein saying she wouldn't have wanted to leave her home at 71 Hamilton Road, he said they could and would have found other lenders and had terms offered to them, so they could have gone elsewhere. And then, I don't need to add to subparagraph 2 in my skeleton. Subparagraph 3, I refer to what the experts say, and in my submission that is an important and critical point that the judge ought to have had greater regard to. The most we get is the appellant's experts saying, well, it's outside the band of reasonable rates, appropriate and reasonable default rates. But outside the band of reasonable rates is different in my submission from extortionate. So I say the most that one can say is it's relatively high. Now, the appellant's skeleton argument tries to do, as it were, a mathematical sleight of hand with the rates by taking the monthly rates and converting them to annual rates, which they say equate to around 42% compounded per year at 3% and 60% at 4%. And they say, well, actually, there's quite a big difference between those two when you put it like that. So it's not a small increase, as you might think, well, it's just 1 percentage point up on a monthly basis. But in a sense, of course, if you convert a monthly rate to an annual rate, the numbers are obviously bigger. The parties in their contract worked on the premise of a monthly rate. So that, in my submission, is the right approach to adopt. But thirdly,
and you no doubt would also say that that is consistent with the fact that the whole term was only 12 months.
Exactly so, my lady. But then if one, as it were, opens up the gap between 3 and 4% per month by converting it to annual figures, you could, of course, strike a point between the 42% and the 60% and say, well, one side of that line's okay, the other's not. But supposing you said, well, 50% on an annualised basis, where the line were to be drawn. If you imagine converting that then back to the monthly rates used in the contract, you're effectively trying to draw a line to say, well, 3.4% might be okay, but 3.5 isn't. And if you're drawing lines in that sort of way, that sort of level of precision, my submission that in itself, the fact that one has to resort to that sort of approach, suggests that we're not in the territory of a penalty. Not the penalty is not the difference between 3.3 and 3.4. It's the difference between 4 and 12 or 4 and 20. That sort of magnitude in my submission. And so on that basis, the judge ought to have found, had he applied the Cavendish test properly, that this rate was not a penalty. Can I then move on to the question of interpretation of clause 12.5, which I think I can deal with quite shortly, given what my learned friend said yesterday. If I may first, though, go back to clause 6, which is in the supplemental bundle behind tab 1 at page 9. I want to firstly highlight clause 6.1, which refers to the borrower paying interest on the amount outstanding. Just deals with interest in general terms. It doesn't cover payment of interest at all. It's not, that 1% is not, contrary to I think what my learned friend said yesterday, compounded. It's 1% simple, and that no doubt is because, as one sees from 6.3, that rate of interest is paid up front. When I say paid up front, of course, effectively it's capitalised into the loan. But it's done on the basis it's not compounded. It's 12%, effectively 12% of the loan is paid as interest for the 12-month period. We then get on to default interest, and really the default provisions in 6.6 are highlights the only situations in which further interest can become payable. And they're either if there's an event of default, or, and I accept there's inevitably overlap here, if the borrower fails to repay amount payable when it is due. And my learned friend yesterday took you through this and accepted that when one looks at 6.4 and how that interrelates with 6.6.2, that what 6.6 is really dealing with is default interest up to but not beyond the repayment date. And I agree with that.
I'm sorry, so you say he accepted that 6.6 provides for default interest only up to the repayment date.
That's what I understood his submissions to be, on the basis of 6.62, referring to the interest becoming payable on the last day of each interest period, and interest periods only run under 6.4 up to the repayment date. They don't run beyond the repayment date. What my learned friend did say, however, is that the last bit of 6.62, when one talks about compounding, he says, well, somehow that gets brought in for post-repayment date interest. And in my submission, that's not right. There's simply no basis to understand that last little bit of 6.62 to have that effect. There's no need to read it in that way because we've got reference to compounding in 12.5, which I'm going to come on to. 6.6 is quite simply purely filling the role of addressing payment of default interest up to the repayment date and not beyond that.
Sorry, so 6.6 only deals with failure to pay up to the repayment date.
Yes. Failure to repay or other default.
And you say that because of the reference to interest period in little 2, which takes you back to how interest period is defined at 6.2.
Well, how it's defined at 6.2, but also, my lady, the limit in 6.4, that interest periods don't extend beyond the repayment date.
But I don't know that I am keeping up. So 6.61 says, upon the occurrence of an event of default and or if the borrower fails to repay any amount payable. Why doesn't that apply where there's been a failure to pay on the repayment date?
All 6.61 does really is set the rate and set the circumstances in which
Yes.
it applies.
So that bit you accept does apply after the repayment date.
It applies. It's brought in as it were. The rate is brought in by
Yes, I see.
12.5.
So the bit you say doesn't. What 6.6 isn't dealing with on your case is compounding after the repayment date.
Well, it's not dealing with payment at all. 6.62 deals with payment of the default interest. First line says the default interest shall be due and payable on the last day of each interest period. So it provides for the interest to be due and payable on a monthly basis up to the repayment date, but not beyond. Once you get to the repayment date, that effectively ceases to have any effect.
So let me just go back to 6.61 then. That provides for interest to accrue at the default rate after the repayment date.
Lord, yes.
But it's not payable if it's after the payment.
Well, it is payable when we get on to 12.5, and this is my point. One sees 6.6 really deals with the position up to the repayment date and not beyond. Once he gets past the repayment date, that's when 12.5 applies.
Well, as I understand it, on your case, there's a qualification to that because it sets a rate after the repayment date. I mean, A says it sets the rate, and B it says it's accruing. So the only bit that wouldn't apply is the compounding.
Sorry, the only bit of
6.6 that wouldn't apply after the repayment date would be compounding, wouldn't it?
well, but also the fact of the interest becoming payable on a monthly basis.
Well, is that really right? Suppose you didn't have 6.62 at all. You just said 6.61. It says you're accruing interest after the repayment date at the particular rate. You, the lender, bring proceedings relying on that. Well, fine, you can.
Well, it establishes there's a debt, but in terms of what 6.62 has is a specific payment obligation.
But if there is a debt?
Well,
What's
yes,
the
I
significance?
accept that, but I think what this goes to is that the point that 12.5 is really dealing with a separate time period. 12.5 is dealing with any monies falling due for payment pursuant to the facility letter and unpaid. And once it falls due for payment and is unpaid, and necessarily after the repayment date, everything that's not been paid is due for payment, that's when 12.5 takes effect. And so in effect, 12.5 comes in to fill the gap, as it were, in relation to the post-repayment date position left by 6.6.
Can we just look at that? So I'm looking at 12.5. I mean, I followed the second sentence, maybe dealing with compounding. So far as the first sentence is concerned, it doesn't say when payment is to be made.
No, because this is post-repayment date, so therefore everything has already fallen due. That's the point.
Well, you say 6.61 doesn't deal with everything because it doesn't give a repayment date. Well, 12.5 doesn't either.
No, but that's because the difference is that 6.6 is confined to the pre-repayment date position.
Is that because of 6.4? Is that why you say that?
My lord, yes.
Because
Yes.
6.4. So that it all rests on 6.4. In some way, you say, confining all of this under 6 to the repayment period.
My lord,
The
yes.
period up to the repayment date.
My lord, yes.
An interest period shall not extend beyond the repayment date.
But there's no reference to interest period in 6.61, and do you accept that 6.61 has a role after the repayment date?
Well, the rate in both 6.1 and 6.6, there's reference back to those in 12.5.
So it sets the rate,
It sets
and
the
it
rate.
says it's accruing.
So really, in a sense, one has at 12.5, relatively straightforward position, saying post-repayment date, then interest is payable, the debt bears interest.
But the language of 12.5 is the same as the language of 6.1, isn't it? 6.61. It's all talking about There's nothing about payability. Is there in 12.5? Payment, due and payable, doesn't appear in 12.5.
It doesn't, but in a
The
sense,
language is the same as 6.61.
it's not necessary at that point because one is after the repayment date. So therefore, necessarily, and I think this is the submission my learned friend made yesterday. At that point, one doesn't need provisions for repayment because, of course, everything is due immediately.
Now I follow that, but that means it's not surprising it's not to be found in 6.61 or 12.5, and it neither says anything about when it's to be paid because it's just accruing. But that is provided for in 6.61.
But 6.62 does deal with payment.
Now 6.62, I agree, is different.
That's different, and but that applies up to the repayment date.
And without expressing any view on whether you're right or wrong, I understand that submission.
I think
but that's limited to compounding, isn't it?
compounding and payment. I mean, it may be that the two go together, and it may be unreal to expect that there were monthly payments in these circumstances. But nevertheless, what one has in 12.5 in my submission is a separate provision dealing very clearly with the post-repayment date position.
Why do you say very clearly?
Well, because it says any monies failing due for payment by the borrower pursuant to this facility letter. So once one is post-repayment date, there will necessarily be monies due, assuming it's not been paid, of course, but there will necessarily be monies due. Once one gets after the repayment date, if a debt is outstanding, we are in the territory covered by clause 12.5. And clause 12.5 makes clear in my submission that in those circumstances, the outstanding debt bears interest either at the rate specified in clause 6.1 or 6.6, if applicable. And so,
and how does that work? If one is in 12.5 territory, it may be the end of the term, or there may have been an event of default before the end of the term. Yes?
lady, yes.
Yes, just checking. And if there's been an event of default before the end of the term, then will be 6.1? Would you say? I'm not convinced that's right. I'm just wondering when 6.1 applies and when 6.6 applies.
Well, I think 6.62 would apply up to the repayment date.
Yeah.
6.1 simply sets out the rate and says that's the rate payable on any amount outstanding.
Yes. So, but when will 6.1 ever be applicable under 12.5? Well,
that in a sense is the question. On my learned friend's submission, 6.1 will never be applicable under 12.5, because 12.5 is only ever engaged post a default of some kind, be it a pre-repayment date default or after the repayment date, when there's necessarily a default of one kind or another.
Why is that not right?
Because 12.5 clearly and expressly provides for the possibility of interest accruing at the rate specified in clause 6.1.
12.5 is in the section headed events of default. So it's all ancillary to the 12.1 to 12.4, isn't it? It's about default.
Well, it is, but of course default is, if there's not a repayment on the repayment date, that too is a default. But what it's making clear is that interest is paid accrues at the rate specified in clause 6.1.
I'm laughing at you're saying it's making it clear.
Well, what it says in terms, I mean, expressly says, specified in clause 6.1 or 6.6 if applicable. And my submission is that there must be circumstances to make sense of this clause and to make sense of that reference to clause 6.1. There must be circumstances in which, although one is in a post-default situation, the rate in clause 6.1 can apply. And on the appellant's interpretation of this clause, clause 6.6 rate would always apply, and there are no circumstances at all in which one would have the application of the clause 6.1 rate. Whereas on the judge's interpretation, which in my submission was correct, if for some reason the default rate in clause 6.6 is not applicable, in other words, for example, because it can't be enforced, then their reference to clause 6.1 in clause 12.5 is made sense of in a very straightforward way. And that is, in my submission, consistent with the way it's drafted. The provision, the starting point under the drafting is for interest to be, the debt to bear interest at the rate specified in clause 6.1.
So really, we should read the words "if applicable" before 6.6. That would make it 6.1 or comma if applicable, comma 6.6. That's what you're saying.
Might be clearer, but I think that is what it as drafted. That is what it's
if
saying.
If applicable qualifies 6.6 and assumes there are occasions when it won't be applicable.
Lord, yes.
But is that sort of assuming that in the drafting it's been assumed that 6.6 might not apply because it might be a penalty?
Yes, for that or for other reasons. It's not unusual in my submission to find fallback submissions in contracts, which effectively say, well, if something in this contract's not enforceable or doesn't apply for some reason, then we have this fallback position. That's not unusual in my submission. It's perfectly commonplace for the parties to do that and to understand it as having effect in that way. And the clause 6.1 rate, one has to remember, applies on any amount that's outstanding under the loan. So there's no inherent reason in 6.1 why that rate shouldn't apply. It applies to any amount outstanding. It's not limited in period of time.
Sorry, tell me that again. 6.1 isn't limited.
No, it simply says the borrower shall pay interest on the amount outstanding. And again, one sort of has this slightly odd way in which it works of 6.1 setting the rate and then 6.3 setting the payment provisions, where payment is up front of the interest that one, as it were, would expect to be accrued under the loan. But to say that, well, 6.1 simply can't apply any later than that, yes, of course, I accept the payment mechanism in 6.3 doesn't cover interest beyond that, but there's nothing in the 6.1 rate itself as a rate of interest, and that's really all 12.5 is doing, referring back to. It's referring back to the rates specified in clause 0.1 and clause 0.6, not any other aspect of those clauses. And so that rate can apply perfectly straightforwardly post-default.
And what amongst the many oddities of this drafting are that 12.5 doesn't refer to an event of default, whereas 6.11 does.
Lord, yes. I mean, that's...
So it could be said that 6.11 should be in 12.5, and 12.5 should be in 6.1. Well, that's really what you're saying, isn't it?
I think if my Lord's point is that this could be drafted better,
more clearly,
I think your Lordship is undoubtedly
yes.
right. But we have to work with what we have. And in my submission, when one looks at 12.5, it clearly, it expressly refers to both of those rates. And the clause ought to be interpreted, as the judges have interpreted, to make sense of the reference to both the rates in 6.1 and 6.6. And the judge's interpretation does allow for circumstances in which the 6.1 rate can apply. And indeed, it's perhaps a natural position to say, well, if you can't get interest under the default rate, the 6.1 rate, as provided for in 12.5, which applies on any amount outstanding, would continue to operate. There's nothing about that that's unenforceable. And indeed, the questions that I was being asked earlier about payment provisions and the fact that 6.61, for example, Lord was saying, well, if that provides for the debt to accrue, would it not naturally be payable? In a sense, one sees the force of that point. But the same is true of 6.1. No payment provision there.
I mean, I do follow how you put it. But A 12.5, if it had been meant to be the sort of fallback you have in mind, might have been expected to explain that. B, it's quite a surprising idea that the parties were catering for the possibility of clause 6.6 being bad as a penalty, and there's no other obvious basis on which they might think that clause 6.6 would be bad. C, there is a coherent scheme in saying clause 6.1 applies up to the repayment date. After that, there's bound to be a default, and all we need is 6.6.
But, my lord, if the starting point for that, as it were, logic is to say, well, 6.1 applies post-repayment date because it doesn't say anything about payment, that logic applies equally to 6.1. If 6.61 applies post-repayment date, so does 6.1. And so, in a sense, if my lord's reading is correct, in 12.5, in a sense, falls away. One has 6.6 or 6.1. If 6.6 falls away because it's a penalty, well, why isn't 6.1 still effective? And one gets to the same result, perhaps by a slightly different route, but one gets to the same result of the 1% standard contractual rate, which is not penal, continuing to apply for as long as there is amount outstanding on the loan. And that really is the judge's conclusion. And he did it via 12.5. My lord's logic does it by clause 6. But in my submission, either way, one gets to the same outcome. And in my submission, when the judge looked at 12.5 and said, well, is clause 6.6 applicable? And he did effectively treat, well, he said, if it's not enforceable, it can't be applicable. That, in my submission, was right. It makes no sense to say that an unenforceable rate is somehow applicable. And in the way the contract works, either by 12.5 or clause 6.1, the standard rate, if I can call it that, must continue to apply. And my learned friend says, well, the problem with all of this is you can't determine what rate is applicable when the contract is entered into. But that point in my submission goes nowhere, because on both interpretations of the contract, before the default rate is held to be penal, the expectation is that what would apply on default. Where the interpretations differ is as to the consequence of the default rate being held to be penal. The appellants say no interest is payable at all, and we say the 1% is still payable. And whichever of those interpretations is right, the consequence of the default rate being held to be unenforceable can be determined when the contract is entered into. One doesn't necessarily know that one will get to the position of a penalty, but on either interpretation, one can understand what the consequence of that interpretation would be at the time the contract is signed.
So I got this right, you're proceeding on the basis that interest can be payable, is recoverable for periods outside interest periods.
My lord, yes. Once one gets into after the repayment date, on any view, there are no more interest periods. One simply has monthly compounding of the applicable rate, whatever that is. And that has to be, in my submission, the position. Otherwise, one has no interest at all after the repayment date.
And in fact, one needs 12.5 rather than your analysis relying on 6.1 and 6.6 standing alone, because you get the compounding in 12.5 last sentence, which wouldn't arise under 6.1 on its own.
If one just read it on its own, but one does, as my lady says, have to look at 12.5, and that clearly provides for compounding in these circumstances. And there's really no reason. There's a relatively straightforward provision in my submission. There's no reason why one shouldn't apply it in that straightforward way.
So is that really what there is to say on the interpretation point?
I think that is, unless
Yes.
my lords or my lady have any further questions on that point.
No.
Then I'm going to move on to costs, where, of course, the test is common ground. Test for an appeal, that is. The appellant faces a high hurdle in overturning the judge's exercise of discretion on costs. There's either got to be an error of principle, or the judge must have left out of account some material factor or taken into account an immaterial factor. And a costs order can only be overturned on the exercise of a discretion if that discretion was exercised in a way that's wholly wrong. And the first point I want to address is the question of who won or lost, which is, as it were, the centre of my learned friend's submissions. The appellants criticised the judge really for not grappling with that question. And in my submission, that's an unjustified criticism. If I could invite you to turn up the consequential judgment at tab 9.2, page 140 of the core bundle. Paragraph 17. He does directly address which party won. He says there was no outright winner. One shouldn't attach too much weight in my submission to the word outright. The judge is plainly addressing here who won and who lost.
Well, Mr. Hutton thinks that outright is the word that indicates the judge went wrong.
Well, in my submission, it doesn't. One has to, it's almost equivalent to saying overall. It's an extempore judgment, and one in my submission shouldn't place too much emphasis on a single word. He's plainly addressing his mind to the question of who won. And he is concluding that there is no winner, really, no overall winner. And the fact that that's his conclusion doesn't mean that he didn't grapple with the question. He plainly did grapple with the question in my submission. The question is whether the answer is a reasonable one to give. And really the complaint that the appellant has to make is that the judge, not that he erred in principle in not addressing the point, but that his assessment of the outcome of the proceedings was wholly wrong. And the fact that, in a sense, that this is not the sort of point which in my submission would justify overturning a costs order is really demonstrated by the difficulty of addressing it. One can only address it by looking back over the proceedings as a whole, including the trial, to try to understand the relative significance of the various points undertaken. And that on an appeal is a difficult exercise in my submission. The judge undertook that exercise, and there's no good reason to second guess his conclusion simply because he didn't conclude that the appellants had won. And indeed, if my learned friend is right, the issues on which the appellants won really were the lion's share of the litigation, the issues on which most of the costs were incurred. And that's essentially the basis on which he says he won. Well, on that footing, the judge's order reflects that. On that footing, if that is right, the judge's order will give them most of their costs.
But that would be, I mean, that's true, but that would still be the wrong approach, wouldn't it? Because if you can identify an overall winner, you are supposed to, and then you make deductions from that starting point.
But, my lord, it doesn't necessarily, even if one said the appellants were the overall winner, it doesn't then at all follow from that they shouldn't pay the respondents' costs of the points, the additional points that they raised and on which they lost.
No,
the two are not inconsistent.
It would definitely mean they got all their costs of the sort of common issues.
Well, to the extent, and the order deals with that, the order essentially says, well, the issues that the judge identified cover everything.
But there is this problem. You take a letter written in the context of the litigation. If you take as your starting point, well, the claimants have won, but you're entitled to credit for the issues on which you won, then when you find a letter that deals with the totality of the litigation, they really get their costs. Whereas if you take the judge's approach, it's a much more difficult exercise.
I accept, practically speaking, it's a more difficult exercise. I'm going to come on to how the judge dealt with that. There's no doubt about that. It's a practically more difficult exercise. It doesn't necessarily mean, though, that as a matter of substance, one ends up at a different place. But having made those preliminary points, I do need to address the question as to which party won more directly. And it's not as straightforward as the appellant suggests. In my submission, the points on which they lost cannot simply be dismissed as being ancillary points in the way they do. And it's worth, in my submission, standing back for a moment and looking at the proceedings in the round. As you've heard, the trigger for the proceedings was the respondent's notice of default to the appellants based on their occupation of 71 Hamilton Road. And the appellants contested that and eventually brought proceedings to challenge it. And the appellant's position is essentially that, well, that notice of default gave rise to the proceedings as a whole. And they say that the dispute was driven by the evidence from the respondents, which was found to be dishonest. And that, they say, was at the heart of the dispute. And they say it rose essentially from the respondents' conduct. And I think a few times yesterday there was reference made to LCL's dishonest scheme. I think the turn of phrase was used on a few occasions. And of course, it's right that two of the respondents' witnesses were found to have given dishonest evidence, as was one of the appellants. But in my submission, one needs to look a bit more closely than that at the judge's findings to see really what the position was, because it's not as anything at all, it doesn't in any way, in my submission, justify the label of LCL's dishonest scheme that was used yesterday. And perhaps I could invite you to turn to paragraph 159 of the judgment, which is at page 121 of the core bundle behind tab 9.1.
159.
Paragraph 159, page 121.
Thank you.
Behind tab 9. And at that paragraph, having gone through the evidence in some detail, the judge essentially summarises his findings of fact as to what the position at drawdown was. And one starts with Houssein. He knew that 71 Hamilton Road was a security address. He knew that the Housseins were prohibited under the terms of the loan from living there. And he understood that the 29th of July inspection was a charade. So he knew all of that. Mrs. Houssein did not directly know any of that, the judge says, but at the top of the next page, the judge says that both Mr. and Mrs. Houssein had effectively constructive knowledge of what was going on, because Houssein was their agent and his knowledge is imputed to them in any event. We then at 3 have Mr. Leondaris. He was, of course, the agent of the appellants, and he is also found to have known the full facts. That 71 Hamilton Road was a security address. The Husseins shouldn't live there, but he knew they intended to continue to do so, and of course he knew about the nature of the inspection on the 29th of July. So just pausing there for a moment, everyone on the appellant's side had actual or constructive knowledge of the true position regarding the promise not to occupy 71 Hamilton Road. Those are the judge's findings. We then, at 4, have the finding that Mr. Stylianides, LCL's representative, may have believed that the Husseins were going to move out before drawdown. Those are important words in my submission. He may have believed they were going to move out, but he knew that as of the 29th of July, they had not. And he was found to have been involved in the charade of the inspection on the 29th of July, together with Mr. Leonardis and Houssein. And then finally, at 6, we have the judge's conclusion that apart from Mr. Stylianides, LCL believed that the Husseins had moved to 61 Hamilton Road, having been told that by Mr. Leonardis via Mr. Stylianides, and having seen the photographs from the inspection. And in the light of that, if I could then ask the court to turn on to page 126 and look at paragraph 185, which are the findings made by the judge in the context of the sham allegation. And the sham allegation, in a sense, really was an allegation of a dishonest scheme. It was a dishonest scheme, effectively, to, well, as the judge put it, to deceive the FCA. A very serious allegation of highly improper conduct that would have amounted to a criminal act. And at 185, the judge identifies one difficulty with the allegation. Is I found at the time that the loan structure was being considered, LCL, including Mr. Stylianides, did intend to enforce the provisions preventing the residential use of the secured properties by the Husseins. So the position as found by the judge was that the appellants knew of the contractual requirement not to reside at 71 Hamilton Road. They knew that the inspection of the property was a charade to mislead LCL, aside from Mr. Stilling's of the true position, and they knew that they didn't intend to comply with that contractual requirement. By contrast, LCL intended that the contractual requirement should be enforced, and even Mr. Stylianides, on the judge's findings, believed that it would be. Now, the problem with all of this from LCL's perspective, of course, was Mr. Stylianides' knowledge of the true position on the 29th of July. And the judge found, and I think it was agreed between the parties, as one sees from paragraph 189 of the judgment on the next page, that LCL was fixed with Mr. Stylianides' knowledge of that matter for the purposes of the waiver issue. And then the judge concludes that as a matter of law, the consequence of that is that LCL waived the residency obligation, essentially because of what Mr. Stylianides knew as to the true position on the 29th of July. And that knowledge was not as a result of LCL cooking up a dishonest scheme to deceive itself as to the residential position. It was rather Mr. Stylianides being involved in a scheme with Mr. Houssein and the appellant's agent, which effectively deceived LCL apart from Mr. Stylianides. So on the judge's findings, the appellants were very much involved in the misleading inspection. They knew essentially that they were evading their contractual obligations by that means. And really what the judge was having to decide, or two things. Firstly, whether as a matter of fact, Mr. Stylianides, unlike others at LCL, knew of the true position on the 29th of July. And second, what the legal consequences for both sides were as the effect of that misleading inspection. But to present the case as being one in which the appellants were essentially innocently thinking that they had done what they ought to do, and that the respondent was complaining about something that it always knew was never going to happen, is in my submission a huge oversimplification of the rather more complicated and nuanced facts that were found by the judge. The second point then, in my submission, to bear in mind when addressing the question on whether or not the points on which the appellants lost were ancillary, and whether everything really, as the appellants say, is consequential on the default issue, is that the appellants could very readily have advanced their case in a much more limited manner. They could have put their case on the premise that they were not in default because the breach had been waived, and therefore they didn't have to repay the loan early or pay interest at the default rate, and that they could and would simply repay the loan when it fell due. And of course, they didn't repay it when it fell due on any view, and they in fact still haven't repaid even those parts of the loan that the judge found to be due. And of course, it was their choice not to limit their case in that way. They sought to avoid repaying any interest or fees in respect of the loan by alleging that the loan was a regulated loan in disguise, the sham point. They sought to avoid the validity of the security by raising undue influence, and then they raised the statutory relief points on the Consumer Rights Act and the Consumer Credits Act. Those points, and particularly the first 2 points, the sham and undue influence points, resulted in a significant expansion of the case. They weren't just ancillary. And indeed, it's instructive in my submission to see how the case was put by the appellants at the very outset. And my lords and my ladies were shown this yesterday. And perhaps I could ask you to go back to the supplementary bundle at page 304 behind tab 16.2. And I think it was said by my learned friend yesterday that this was the first letter from the appellant's solicitors, certainly the first letter we have in the bundle. And we see on page 304, 4 paragraphs under the heading in the middle of the page, allegations against Mrs. Houssein. And the solicitors were at that stage still attempting to obtain the correspondence files, so it was plainly early. And at 305, under the heading facility agreement, we have what is essentially the sham point being set out. They say that the loan was an attempt to disguise a regulated mortgage contract, and the facility letter is unenforceable. And they set out their reasons why they say that's the position. And then at the top of the next page, having reserved their rights to make an application to the court to declare the facility letter void, they say entirely without prejudice to our client's primary contentions stated above. Even if the letter is held to be valid, which is denied, they then make further points. But it's striking in my submission that they are saying there that the sham point is their primary point. Not ancillary, is now being said. But at the outset of the proceedings, it was said to be their primary point. And of course, the case was then, and I should just say something actually about the effect of the sham allegation, because it was said yesterday by my learned friend that, well, the effect of it was that interest and any costs payable under the mortgage contract wouldn't be enforceable, but the principal would still be repayable. And strictly that's right, as a matter of law. And of course, it's not simply the interest and costs that would fall away, the security would fall away if the contract was unenforceable as well. And what one would then have was an unsecured debt to a company. And we know from the evidence of Mr. Houssein, and just for my lady's note, it's paragraph 45 of his statement at page 56 of the supplemental bundle. He says that the company CK Investments was essentially a dormant company before this loan. It didn't even have a bank account, he says. So if one goes to the position in which there's no interest and no costs and no security, then effectively one has an unsecured debt owed by a company that will simply be declared to be insolvent. So the whole thing will simply go. So this is a critical point from the respondent's point of view. And of course, the allegation of sham was pleaded out. And I'm not going to take you to the pleading on that point, but we see it's necessarily a broad allegation, because it's an allegation that inherently involves the whole circumstances in which this loan was made. It's not focused narrowly on what happened on the 29th of July. Much broader point than that, requiring much broader evidence. Then, just to illustrate the scope of the undue influence case, in the core bundle, if I could invite you please to turn to page 187 behind tab 13. One sees there undue influence is pleaded out, and at the bottom of the page we have particulars of undue influence, and one sees the sort of matters that are raised about the background of the Mrs. Houssein and her relationship with her husband, and a whole array of matters stretch over to the bottom of page 189, all of which raise a wide range of factual matters. We have all of which have only arise because of the undue influence allegation. At paragraph 101, we have the allegation that the respondent, by Mr. Stylianides, or alternatively by its agent, Premier, and although the judge found Mr. Leon Laris was the appellant's agent, what was alleged in the particulars was that he was the respondent's agent. It said they knew or ought to have known of the said undue influence of Ali Houssein. And then there's various points made, as one would expect, on the legal advice that was taken. And we have a series of allegations, essentially at 104, as regarding the nature and the scope of the legal advice that was received. And all of that is relevant only to undue influence. And indeed, one has a section in the judge's judgment, I think starting at about paragraph 148, which is headed "The advice given by Mr. Fari," and that's relevant only because of the undue influence allegations. Against that context, if I could then please turn to the judge's judgment, and if I could first take you to page 98 behind tab 9.1 in the core, just to make a point on paragraph 57, which again relates to the impact of the undue influence point. And I think there was a question from the court yesterday about who owns what in terms of the security properties.
Sorry, I wasn't keeping up. Where did you tell us to go?
It's in the core bundle, my
Yes.
lord. Divided 9.1, page 98, which is paragraph 57 of the judge's judgment.
Yes.
And one sees there, he sets out neatly who owns what. And of the 6 properties, 3 are jointly owned by Mr. and Mrs. Houssein. 1 was owned by Mrs. Houssein alone, and 2 were owned by Mr. Houssein. But of course, that's the position in early June 2000. Those jointly owned properties, one presumes, and there's nothing to suggest to the contrary, would have passed by survivorship to Mrs. Houssein as sole owner. So if one is challenging by an undue influence allegation the enforceability of the properties as insofar as they're owned by Mrs. Houssein, that affects 4 out of the 6 properties.
I mean, you may be right. At the same time, it wouldn't be at all surprising if the reference to being owned jointly actually referred to owned as tenants in common in shares, in which case the survivorship wouldn't apply.
It wouldn't. We only see the phrase about them being jointly owned. I'm essentially taking the judge at face value when he says that. When he says jointly owned, he means jointly owned. If I can then ask you to turn on to page 125, paragraph 181, where the judge addresses the sham argument. It is not insignificant in my submission that he addresses the sham point first. He didn't see this as some minor add-on. This was the first point that he turned to. And it was, as the judge said, a broad argument. A broad argument that the purpose of the loan was improperly disguised. And he notes at 1H3 the seriousness of that allegation, describing it as effectively an allegation of deception. And although he says it's a baseless point, its nature necessarily required an examination of a broad range of facts and about the circumstances in which the loan claimed to be made. And then if one contrasts that with paragraph 189 on page 127, contrast that with what the judge said was the critical issue on breach. He said it potentially involved numerous issues, but in the end, only one was mattered. The question of who knew what about what happened on the 29th of July. That's a much narrower focus. And then at paragraph 210, on page 130, the judge turns to undue influence, which takes up a fair amount of his judgment. And at 213, he highlights 2 stages in the analysis. Firstly, was there undue influence at all? And secondly, was LCL on notice of it? And both of those issues involve additional factual points beyond those necessary to the no breach case. And indeed, at 218, we see the factual premise of the allegation of undue influence dealt with by the judge. And again, as I said, the factual question regarding the advice also turns only on this.
Although you say that in paragraph 189, it's potentially involved numerous issues, but in the end, only one was relevant. We have to look back, don't we, as said earlier in the judgment when he was analysing the evidence. Quite a lot of the evidence led up to that particular assertion, didn't it?
Well, there's evidence of the context of, puts those events in context, of course. But the reason that those earlier events had to be addressed in such detail was, in my submission, largely because of the sham allegation. That was what really brought those into focus in a way that wouldn't otherwise have been the case. And finally, I just wanted to highlight paragraph 233 on page 135, where the judge deals with the consumer claim. And we see the first consumer claim, 233, the section 62 of the Consumer Rights Act, that was abandoned by the claimants on the last day of trial. But since it follows, it was pursued by them all the way up to that point. And then 234, the other claim under Section 140A of the Consumer Credit Act, that fails essentially, stood or falls with the sham argument. But again, it had to be dealt with.
Going back to, sorry, I'm interrupting you again, forgive me, but going back to your primary point that sham came first to the judgment, wouldn't it logically come first to the judgment? Because it would, if the whole thing was a sham, then you wouldn't have to breach. Duty, breach, damage.
My Lord, yes, and there's all sorts of reasons why a judge may order the judgment in that particular way, and I don't attach huge weight to that particular factor. But what I do submit is that it indicates that this wasn't a trivial point that can just be dealt with at the end as an add-on. It's a point that had to be dealt with up front. Perhaps for the reasons my Lord has given, but it was nonetheless not determinative, but indicative of this being a significant point, not something that was just an add-on. It doesn't really change things in the way that the appellants now seek to contend. And really, when one looks at all of those materials in together, and it's a bit of a whistle-stop tour, and it's, in a sense, necessarily whistle-stop, not simply because of the time pressures we're under this morning, but because this is an appeal. One can't get out the whole trial bundle and go through the whole thing. That would be an impossible exercise, even if we weren't under time pressure. And that, of course, is one of the problems that any appellate court faces with looking at this sort of question on an appeal. It's very difficult for this court, in my respectful submission, to grapple with these issues and have the same sort of familiarity that the trial judge had. The trial judge heard all of this, and his conclusion was that, well, when balance is up, there is no overall winner. Each party won on some bits of their case, some important bits of their case, and lost on others. But they were, as the judge said, discrete points. They weren't sub-points. One could drop the sham argument entirely, and there would be no detriment to the other parts of the case. It's not like they were put in the alternative or anything like that. It's not like they depend on sort of slightly different factual scenarios and the judge might find one or the other. It's an entirely different and much wider set of allegations, same as can be said of the undue influence point. So in the light of that, I just want to pick up on the two authorities on the question of who won, which both provide useful tests. I think the court was referred yesterday to the test formulated by the Master of the Rolls, Sir Thomas Bingham, which essentially has the plaintiff won or the claimant won anything of value, which he could not have won without fighting the action, as the defendant substantially denied the plaintiff of a prize which the plaintiff or claimant sought to win. And in my submission, the respondent has won something by denying the appellant's attempt to essentially escape all liability for costs and interests on the loan, and by preventing it from enforcing its security, effectively escaping the liability altogether in all practical terms, and also via the undue influence argument to escape from some of the security by another route. That was a success in my submission. And the second test, which I don't think the court was taken to yesterday, is in Cupelli and Sicchetti. If I could ask the court to take out the authorities bundle and turn, it will be in the second volume behind tab 15. And I think my learned friend took you to this case at a different point yesterday. I think he took you to page 535, into paragraph 5, where Lord Justice Higginbotham sets out the test applicable on an appeal against a costs order. I refer to paragraphs 10 to 12, and one sees there reference to, in paragraph 10, one sees a quotation from the decision in Day and Day, where Lord Justice Ward says, I would go further and say that in a case like this, the question of who is the unsuccessful party can easily be determined by deciding who has to write the cheque at the end of the case. And that similar test is referred to in another authority, essentially endorsed. And I accept that's a quick test. But applying that quick test here, the answer is clear. It's the appellants who sought to avoid writing as large a cheque as they are ending up having to write, and on their alternative case had another fallback position with, again, for a slightly smaller cheque, and they are having to write a cheque. Not as substantial a cheque as it would have been on our primary case, I accept that, but nonetheless, they're the ones having to write the cheque at the end of it all. And on that footing, in my submission, the respondent could reasonably be said to have won. And I don't say on that basis that the judge ought to have found that the respondent was the overall winner. But the fact that one has that sort of test, albeit only a quick test, pointing in that direction in my submission demonstrates that when one looks at everything in the round, the judge was perfectly justified in concluding that there was no overall winner here. It was 6 of one, half a dozen of another effectively a score draw. And this court may have reached a different view, but in my submission it cannot be said that the judge's conclusion was one that was wholly wrong. Can I then say something about the offers that my learned friend took the court to in some detail yesterday? I don't need to go back through those because you've seen them all. And of course, I say you've seen them all, in a sense you've seen what's in the bundle, which is a slightly one-sided selection of the correspondence. If one had everything, it would be much fuller, and one would see plenty coming back the other way from the respondents that one doesn't see here. And you were taken, I think, to the early offers that involved an offer to pay 1.2 million at the outset and then a further £650,000. And one sees that 1.2 million that was offered, although that offer in full wasn't accepted, of course, the 1.2 million was eventually paid. Essentially, a partial deal was done because that was done on a consensual basis with the respondents agreeing to release some of the security in return for that payment. So there was effectively a partial deal that facilitated that. And it was all dependent on the appellant's ability to refinance. That's how they financed that payment. And my instructions are that one of the problems earlier was a lack of confidence in whether or not that refinancing could in fact be obtained. And the fact that it didn't actually happen until the end of May rather bears that out. But of course, one also has to remember that that payment of 1.2 million was really just a part payment of a debt that was going to be due in any event. And can I just make further that point about the respondents' involvement in these settlement discussions by taking you to the supplemental bundle, divider 1610, page 325. Which is part of a letter written by the appellant solicitors to the respondents, then solicitors, shortly before consequential hearing. I think shortly before it was originally listed to be heard in July. The letter sent on the 18th, dated the 18th of July. And on 325, at paragraph 35, you will recall that my learned friend slightly elliptically referred at one point to a sort of pause in the correspondence that he was taking the court through. Paragraph 35, one sees that a letter dated the 21st of July, the respondents, through their solicitors, made an offer of mediation. And that was some dispute over the terms of the costs of that, but that was then eventually agreed, and the mediation took place. And quite rightly, no one goes into quite what happened at the mediation, but it was obviously not successful. And then the offers that were made in October, 4th of October offer that the court was taken to yesterday, 700,000, further 100,000 in a year's time. And then the counter offer, one sees at paragraph 37, shortly after that, to accept 750,000 with a further 100,000 to be paid in 6 months' time. And they then say you made further proposals under cover of an email dated 7th of October, which was headed without prejudice and subject to contract. The without prejudice heading was not expressed to be save us to costs. And in view of the absence of any such qualification, we do not refer to those proposals here. Well, I don't obviously seek to go behind that, but what that demonstrates is that there were other things going on that are not disclosed in this letter, quite properly not disclosed. There are other things going on in the background. And so one gets to the point where the offers that one sees had to have been made were not that far apart in monetary terms. But the deal wasn't done. There were other discussions happening.
What do we take from all of this in relation to what the judge should have taken into account? Because it was said yesterday, of course, he only makes a cursory remark about would have been better for the respondents to have settled.
Well, he does, and in a sense, with hindsight, I think he says with hindsight, inevitably, one can almost always say that. But the fact is that the parties got very close to a deal. Those offers involved the respondent giving significant ground on the claim to penalty interest, and the appellants really didn't go much beyond what they were inevitably to pay in any event, unless they succeeded, of course, on their points.
I mean,
Their sham argument.
I mean, this much must be true, mustn't it? When you say, well, look, the claimants were claiming relief, which would have got them out of paying all interest and costs, and there would have been no security. What we do see from the offers is that's not the position they're taking. They may have taken it on the pleadings, but they were willing to pay you more than would be due on the basis of non-default interest.
Well, what it comes down to, Lord, is the penalty issue. The respondents were pressing essentially penalty interest. I think penalty interest and, of course, costs, because there was a receivership. And the receivership had costs associated with it, which could be passed on. And I instructed the figures about, when the offer was about 1.8 million, the excess that the appellants were seeking was about $500,000.
But looked at in those terms, you lost, because there was no event of default. There was, on any view, no default interest due before the repayment date. The appointment of receivers was unjustified. You had to pick up the bill for the receivers. There was no question of the claimants doing so. So they won on all that.
Well, they did win on that. And of course, the point is, the respondents were ordered to bear the costs of all of that. That's, in my submission, the answer to that, is that yes, we did lose on that. And as a result of not accepting the offer, and a result of pressing on and fighting on that issue, we lost, and then we bear the costs. That, in my submission, is a reasonable and unsurprising position. But what then one then has to ask, what about everything else? My own friend says essentially, well, they won on that issue, and since everything else then comes with it. But one has to look at two points in my submission. Firstly, the appellants didn't simply repay the loan when it fell due. They could have done that. Even now, as I've said, they haven't. And had they done that, they would have unilaterally removed from consideration several matters that actually ended up being an issue, and are still an issue today. The point of construction simply wouldn't have arisen had they paid the loan when it was due on the 7th of August 2021. And secondly, as I've said, the other points that they raised, the sham, the undue influence points, they arose because of the appellant's choice to pursue them. And in my submission, the mere fact that they made these offers at a level, in a sense, slightly where the appellant's liability was ultimately found to be due, and of course I accept what it all comes down to the point in time at which you look at it. If you look at the time in which the offers are made, it's less favourable to the respondents. If you look at it at trial, more favourable. If you look at it now, the total amount payable goes beyond any of these offers.
But on the basis of the judge's findings, leaving aside your cross appeal, all the offers made prior to the repayment date, which were quite a few, were more favourable to you than you've achieved.
Well, it depends on the time at which one looks at it. If one looks at it at the date of the order, the sum payable then was just over 2 million. So it wasn't at that date. And I accept it changes If you go back further and look at the time when the offers were made, I accept the position is different.
I mean, if we assume what we now know from the judge's judgment, when each of these offers was made, it was more favourable to you than you were entitled to.
Yes, subject to the appellants being able to make good on their refinancing, which of course all of these offers essentially were subject to. If they hadn't been able to refinance, the offers wouldn't have gone any further. They did need to refinance. They didn't do that quite as quickly at the 1.2 million as they thought they would. We don't know what the position is with the balance, but we do know they haven't in fact paid it.
And I see the problem about balance, but actually, on the judge's findings, when you were paid the 1.2 million, well, you obviously weren't due it, and there was no question of any outstanding interest. I mean, that had been paid up front.
Well, capitalised. It wasn't in fact paid. It was simply capitalised into the loan.
Well, it was paid and then you lent that amount.
It was notionally paid. But the submission I make on the basis of all of this, my lord, is that the fact that those offers were made at that time cannot effectively give the appellants carte blanche then to raise a number of other points, the sham point, the undue influence point, which seek to bring them back down below the offers that they've made, and to raise those points unsuccessfully without there being any consequence of them doing so.
Doesn't that take us back to how Part 44 works? You have to look at who is the overall winner, and that's the process that the rule requires us, that the judge to go through.
Yes.
And then, having done that, you then take these other points into account. But essentially, there has to be an overall winner.
Well, there doesn't have to be an overall winner. The judge has to look at.
Well, the judge has to
consider that, and it must be legitimate to find that no one won.
For my part, I go back to your very first point, which is that is to downplay the judge's use of the word outright, because there plainly wasn't an outright winner in this case.
No, I don't think anyone suggests that.
But that wasn't the question, was it? The question was there an overall winner?
Well, there wasn't in my submission, and effectively that's what the judge is concluding. And the question is, was that beyond the limits of effectively his discretion in assessing the outcome? And in my submission, it wasn't. And it wasn't also beyond the limits of his discretion to determine that on the additional points that they raised, sham, undue influence, etc., that the appellant should bear the cost of that, having lost. Other judges may well approach it in a different way. I accept that. Of course, there are different things that one can do. But to say that one cannot, in my submission, say that decision was outside entirely the limits of his discretion. So that, I think, deals with the sort of fundamental points made by my learned friend. There's then a couple of points on the terms of the judgment made by my learned friend. And if I could invite the court to turn back to the consequential judgment on tab 9.2 of the core bundle, and paragraph 15 of that at page 140. And this is the passage where, paragraph 15, the judge refers to the starting point as being the conduct of the parties. And my learned friend says, well, that's wrong under the rules. The starting point is who won. But really all the judge is doing here is considering a slightly discrete and separate point as to how to deal with the fact of these witnesses being found to have given dishonest evidence. He decides to deal with that by disallowing either party from recovering the costs of those witnesses. And in a sense, that's separate from his general order on costs. And then he goes on at paragraph 17 to deal with the general order. And there he does start with the question of who won. And in a sense, in my submission, it's neither here nor there that paragraphs 15 and 16 of the judgment come first. One could take them out, transport them to the end of the judgment, and other than the first sentence where it talks about the starting point,
Yes, you think
it'd be the same logic and the same result.
you think that we should read that as I bear in mind an important point in this case, rather than the starting.
It's basically a separate point that he deals with separately and discreetly. And when he moves on to the overall order, he does take as his starting point who won overall. And really, in my submission, in the context of an extempore judgment, to simply take the words, well, the starting point in this case, and to read from that an error of principle is, in my submission, wrong.
Where does he say here the claimants won on the question whether there was an event of default? Does he actually specifically refer to that in his judgment?
Well, in paragraph 19, he does say the costs of and associated with the default interest point.
When he goes through the points,
He goes through
17,
the points.
in 17,
And
he
I think there's one that he overlooks, and is, yes, at page 143, which I think is behind the next tab. After he's finished his judgment, Mr. Maynard, for I think the appellants, says, my lord has not addressed separately the issue of whether there was a breach of the facility letter by occupation of the premises. And the judge says, yes, sorry, you were successful on that one, you get your costs on that one. So it may have slipped his mind when he's giving his judgment, but plainly he intended to and did order the respondents, the appellants, get their costs on that point.
So the point which the claimants say, or the appellants say, was the factor which made they were the overall winner, slipped his mind.
Well, it certainly slipped his mind when he was listing out the issues in paragraph 19. Whether it follows from that, but it slipped his mind entirely. I submit one shouldn't draw that conclusion. He simply was sort of reading off a list of issues and he overlooked one of them to suggest that he didn't have in his mind what was, on any view, one of the important issues in the case. In my submission, doesn't follow from that. So that's what I say about that issue. The other point is that my own friend says, well, the rules require, if a judge is going to make an issue-based costs order, the judge should consider the making of a proportionate costs order. And the short answer to that point is that he did do so. And one sees that at paragraph 17, where he says, I do not believe that a discount for the recoverability of costs would reflect success and failure in this case. He deals with it briefly, but he does consider the notion of a discount, and he rejects it. And at paragraph 20...
As a matter of fact, that could be dealing with a different point. That could be dealing with the sort of normal order where you say, well, one side is in principle the overall winner, and then you knock off a bit. Whereas once you've decided that there are issues that should go both ways, you can still reflect that in percentages.
My lord, yes, you can do it both ways. It's, in a sense, different ways of looking at the same thing. Either way, one ends up with a proportionate order. In my submission, he's considered that. He's considered it, and he's rejected it. And at paragraph 20, at the end of the judgment, when he says it's impossible to stay at this stage which party will be the overall paying party, I think the Lord was surprised at that when taken to it yesterday. In my submission, it's not surprising, given what we've seen the judge has found, that this is actually a finely balanced question as to who won and who lost and to where the overall balance of the issues lies. In that context, in my submission, it's not surprising that he couldn't work out quite where the parties would end up when they went through this process. And that again is consistent with the judge's view that he wasn't in a position to make a proportionate costs order. And turning on to the transcript behind tab 9.3, and again I think you were taken to this yesterday, but at page 144, lines 20 to 25, the judge recognises He shouldn't make an issue-based costs order lightly, and he's conscious there's a lot of work that goes into it. But then he says it's simply on this matter, given the success on both sides, and the fact that it cannot readily be reflected in a percentage discount of either party's costs. So really he's saying, I'm not in a position to say what an appropriate discount would be. And that, in my submission, is a perfectly good reason. One might say it is the best reason for not making an order of that kind. And an issue-based costs order in those circumstances is a natural alternative. Then I just want to pick up on the question of serious irregularity, which was raised or emerged somewhat tentatively in the course of my learned friend's submissions yesterday. And the fact that it emerged only then in my submission suggests that there's not much in it. There is very often many different costs orders that a court could make. And very often you have the situation where one party has one extreme and the other party has another extreme, and the judge concludes that the right outcome is somewhere in the middle. And it's often that the ultimate outcome on a costs order is different from what either party was seeking. And one might say it might have been better for the judge to have canvassed the possibility of an issue-based costs order with the parties. But the fact that that didn't happen does not, in my submission, amount to a serious irregularity, which justifies overturning that order on appeal. Then the final point is, well, if in a sense the court is against me and a proportionate order ought to be made, the question then becomes, well, what ought that order to be? And in my submission, any proportionate order should really reflect the substance of the judge's decision in the sense of which party bears which set of costs. All that this court should do, if it thinks that a proportionate costs order is appropriate, is essentially convert that issue-based order into a proportionate order, into a percentage order. And my learned friend, although he didn't touch on this point yesterday, say essentially they should have their costs subject to a most of 20% deduction, because they say, well, these points are just ancillary. And while I accept it's a broad brush exercise, one has to have some rationalised basis for whatever percentage one alights upon. And it's very difficult in my submission to do that, which is in a sense why the judge went down the road he did. But in my submission, 20% is far too low. When one looks at the totality of the points and the significance of the various points, in my submission, it's more realistic to suggest that the appellants succeeded on around 60% of their case at the very most, and adopting the same approach as the judge, the respondents should recover around 40% of the costs to reflect the reality of the points on which they won and the appellants lost. And that, in my submission, again, broad brush, with a very broad brush, gives you a recovery for the appellants of around 20%. And that, in my submission, is a more realistic proportionate order. It also reflects, in my submission, and it's important that it should reflect, the trial judge's analysis of the position, that it's far from clear-cut to determine, in the circumstances, which party should be the overall paying party, given the extent of each party's success and failure. On that basis, one might even say 20% is somewhat generous. And of course, the appellant's argument, well, they should get 80% of their costs, suggests this is not clear-cut at all. And that's very different from the view taken by the judge. Can I then very briefly deal with indemnity costs? And I think I can probably take this quite quickly, given the points I've already made. The first question is the question of the impact of the dishonest evidence on the basis of costs. And I accept the general principle the giving of dishonest evidence can often mean that an award on costs on the indemnity basis is appropriate. But where one has dishonest evidence on both sides, one starts inevitably, in my submission, to move away from that. And where one also has the very serious sham allegation that was advanced by the appellants, found by the judge to be essentially an allegation of dishonesty. That's not something that arose from any evidence that was given dishonestly by the respondent, the point entirely of the appellant's own making. And that's a factor in my submission that is rightly and properly taken into account. Both of those points, the fact of the appellant's dishonest evidence and the unsuccessful allegations of essentially fraud advanced by the appellant, and except, as my learned friend said yesterday, there's no general rule that drives you to indemnity costs, but it usually does. Those point strongly towards actually the appellant's paying costs on the indemnity basis. And where one can well see in my submission why the judge ended up as essentially seeing the two problems and difficulties cancelling each other out. And this moves beyond what would be the usual response to dishonestly given evidence. And it was reasonable for the judge to conclude that both sides should bear costs on the standard basis. And from a learned friend to say, well, the judge should, as it were, undertake a balancing exercise. There's dishonesty on both sides and whose dishonesty was more significant. That, in my submission, is an unattractive exercise to be carrying out. But even if it might be a possible approach, it was, in my submission, reasonable and certainly not wholly wrong for the judge to decide not to undertake it. And once that's out the way, as it were, to say that, well, costs should be on the standard basis as normal, that, in my submission, is well within the judge's discretion. And then the second point on which it said costs should be on the indemnity basis is on the basis of the offers that were made. But of course, outside the scope of Part 36, the rejection of a settlement offer is not normally regarded as grounds for an award of indemnity costs. And one sees that from the decision in Kiam and MGM, tab 2 of the authorities bundle, with the key passage being on page 23 at paragraph 13. And so, in that context, whilst accepting under Part 44, one has to take into account offers. The judge was right to not conclude that the rejection of a settlement offer didn't, of itself, justify an award of indemnity costs. It may justify some costs on the standard basis, and it did result in costs on the standard basis, but no more than that. Lord, may I just have a moment?
Please.
Unless my lords or my lady have any further questions. Those are.
Thank you very much, Mr. Wheeler. That's very helpful. Mr. Khan, you're going next, aren't you?
I'm grateful. Thank you. Well, can I deal with the cross appeal first?
Yes.
Can I begin by summarising our position in relation to the cross appeal? We say that whilst the manner in which the judge expressed his views is far from perfect, and we recognise that, we say the sense of the judge's judgment is clear. Not only did he recognise the correct test as to whether or not the default rate was a penalty, but he applied it in the correct manner. I'll take your lordships back to his judgment in due course, but we say it's quite clear from the judgment that the judge not only directed his mind to the second of Mr. Justice Fancourt's three-limb test, but also sought to answer the third question, whether, as it was put by Lord Newberger and Lord Sumption at paragraph 32 in the MacDessie case, the provision imposes a detriment on the contract breaker out of all proportion to the legitimate interest the innocent party has in enforcement. But we say in order to answer that third question, you need to know what the legitimate interest of the innocent party is. And can I take you briefly to MacDessie, which is in the authorities bundle at tab 13, and just remind your lordships what Lord Mance says. Can I begin at tab 13 at page 355, the paragraph 152. And about halfway down paragraph 152, between letters E and F, there's a sentence where he says, what is necessary in each case. He says, what is necessary in each case is to consider first whether any, and if so what, legitimate business interest is served and protected by the clause, and second, whether assuming such an interest to exist, provision made for the interest is nevertheless in the circumstances extravagant, exorbitant, or unconscionable. And then if I can invite you to turn back to page 353, just to remind you the paragraphs right at the bottom of 353, paragraphs 147 and 148. So the paragraph 147, he makes the point that in a series of cases, courts have held that provisions in loan agreements for uplifting for default should not be regarded as penalties, save, he says, where the uplift is evidently extravagant. And then he goes on to say in 148 that the rationale of these cases is that the default bears on the credit risk and may also bear on the cost of administering the loan. The uplift is conditioned on the breach, but the breach reflects directly on the continuing appropriateness of the originally agreed interest terms. In substance, the uplift amounts to a variation of the original terms. If, on the other hand, it's evident from the size of the uplift that it is in its nature a punishment rather than an ordinary commercial re-rating to reflect a change in risk, then it will still be disallowed as a penalty. And Lords, the learned judge in this case, we say, recognised that expressly in his judgment at paragraph 201, where he refers to, and that's at page 129 in the core bundle, where he refers to Mr. Justice Bryan in the Cargill case, stating that there was a good commercial justification for charging a higher rate after a default, since a person who is defaulted is necessarily a worse credit risk. So he's there expressly recognising the point that my learned friend presses upon you, which is that there are lots of cases that say that where someone has defaulted, there is legitimate use of a default interest rate, of a default interest rate. And we don't dispute that. And we say not only did the judge recognise that, but it follows from the fact that the judge recognised that. But what he then goes on to say is not simply there is an increased credit risk here, and therefore I need to find some sort of justification. That actually what he's saying is, let's look at the default rate in this case. Can it be justified? And so what we say is that what he actually does in the judgment is to answer questions 2 and 3 of Mr. Justice Fancourt's 3 questions together. And we say that's perfectly proper because questions 2 and 3 are linked. You cannot know whether or not the default rate is exorbitant or extravagant, or whichever of the formulations you use, unless you know what the legitimate commercial interest of the innocent party in protecting their interest is. So with all due respect to the judge, we say that the way he expressed it was somewhat clumsy, but that actually what he did was apply the correct test. And that test has to be applied objectively and not subjectively. We agree with that. But it must be applied to the facts of the individual case. We get that from, again, if you look in MacDessie at the relatively short judgment of Lord Toulson, which we were taken to by my learned friend yesterday. It's at page 393 in the authorities bundle behind tab 13. So page 393, paragraph 293, Lord Toulson highlights and endorses Lord Hodge's statement at paragraph 255 as to what the correct test is. And then he says this, 3 lines from the end: parties and courts should focus on that test, bearing in mind A, that it is impossible to lay down abstract rules about what may or may not be extravagant or unconscionable, because it depends on the particular facts and circumstances established in the individual case. And then he cites authority for that proposition, and then he goes on to say extravagant or unconscionable are strong words. So we say, yes, it has to be objective, but also it has to be on the particular facts of the particular case.
Just to be clear, do you mean you look at, well, I suppose the point I have in mind is are you saying you have to look at the particular breach, or can you have a default rate that applies to a class of breaches and assess the appropriateness of that more general default rate by reference to the facts of the case?
You can do that, but I'd say it goes further than just the type of breach. That in looking at the facts of the case, you look at whether or not the default rate which has been set is a default rate in relation to this particular transaction between these parties, having regard to the parties in the case. Now, that where Malone and Friends' point is right about subjectivity is that what you can't say is, well, because Mrs. Houssein would find it difficult to pay a default rate, that means the default rate is a penalty. But what you can say is, given the circumstances of this case, and we say this is what the judge did, he looked at the loan-to-value rate, which in this particular case was very low for a bridging loan, 54% loan-to-value. And that assisted him in deciding whether or not the default rate in this case was a penalty. But I'll come back to that when we look at the judgment. Can I take you briefly to a case which is not in the authorities bundle? We provided a copy of this to my friend Mr. Wheeler last night. Can I hand this up? Thank you. And I did ask my own friend Mr. Wheeler whether or not he wanted me to hand this up to your lordship before he finished his submissions, and said that that wasn't necessary. Thank you. It's a case called White and Davenham Trust. It's a decision of Mr. Justice Floyd in 2011, and it's an appeal from an insolvency deputy registrar in relation to, again, bridging finance provided by Davenham Trust Limited. You'll see from the head note that the company, St George's Property Services, purchased the property with the assistance of a short-term loan provided by Davenham Trust Limited, and the standard interest was 1.6% per month, and the default rate of interest was 3% per month. And the question was whether or not that was a penalty, and it was linked in that particular case to the setting aside of a statutory demand which had been served on one of the guarantors who had given a guarantee at the same time that the facility was entered into. Can I take you straight away to the particular passages which are relevant, which start at paragraph 51, page 628 in the top left of the report. And what happened in this case was that Davenham Trust were seeking to rely on another case in which they had been involved, called Davenham Trust and Home Gold Limited, in which a different judge had considered an application by Davenham for summary judgment against guarantors, on the strength of which the guarantors had said, we've got a triable issue because it's because your default rate is a penalty. And at 51, Mr. Justice Floyd cites from Lordsvale Finance. And then at 54, and this is the important part, in Davenham and Homegold, the judge had the benefit of extensive and unchallenged evidence from a director of Davenham concerning market rates at the time of the relevant agreement, the risk factors involved, and the rationale for the default rate. It was on the basis of that state of the evidence that he felt able in that case to reject the contention that the rate rise was a penalty. No evidence of that kind adduced in Davenham Trust and Homegold was before the Deputy Registrar in the present case. And then he cites from the judgment of the Deputy Registrar, what the Deputy Registrar had done was to say, well, the factual matrix in that case is the same as the factual matrix in this case, and therefore, because it was held not to be a penalty in that case, it's not a penalty in this case, and therefore I'm not going to set aside the statutory demand. And then at paragraph 56, counsel makes a point about the Deputy Registrar falling into the trap of looking at apparently small percentage increases, which is obviously relevant to this case, but not terribly, of interest to this case, but not terribly relevant. And then Mr. Justice Floyd says that whilst it's tempting to draw on the judge's judgment in Davenham and Homegold, where the interest rates and other matters are very similar, it's clear that the judge there was heavily influenced by the unchallenged evidence from Davenham, which was not properly before the Deputy Registrar. Authorities are a source of legal principle, but not of evidence. And then he says the evidence before the Deputy Registrar was a different kind. The borrower's evidence was that 36% was a grossly exorbitant rate of interest. 36%, I should say, was the rate that when you took the compounded monthly rate as an annual rate. He compared the amount that they had to pay in respect of that property in respect of a different property. He gave evidence that the risks that Davenham undertook didn't justify the rate of interest, given that Davenham was a secured lender who had obtained a valuation of Gowan before the sums were advanced. In addition, they could look to Ringmer for additional security, a different property for additional security. At the date of the execution, there was unused equity and there were personal guarantees. And then at 59, the evidence in answer came from a solicitor instructed by Davenham. Her affidavit made the points accepted by the Deputy Registrar concerning the commercial nature of the high proportion of loan to value, the fact that the terms were well known. A marked lack of any evidence, Mr. Justice Floyd says, directed the rationale for the substantial increase in interest rates on default, as opposed to the reason for the initial interest rate. In these circumstances, it appears to me there's a genuinely triable issue. What's interesting in passing about that, of course, is that he comes to, on exactly the same rates, not completely the opposite, but he says there's a triable issue, whereas, of course, in the other case, the result was that there was no triable issue. So, contrast that, we say, with the evidence in this case. And can I take you briefly to that? It's in the supplementary bundle at page 90. And this was the evidence of Mr. Theophanus. It's behind tab 8.3. And there is literally one paragraph of his evidence at paragraph 15, where he says, regarding our default rate of 3% above standard, this is a standard term in all our loans. It was set in and around 2019. I understand that it's consistent with the market. The decision was made by the directors. I refer to our document in our list, which lists the terms being offered by our competitors in 2019. That's it. So you don't get what they had in white, which was, these are the reasons why we are charging 4% or whatever the percentage is on default, and which the judge in the other case, the other Davenham case, took into account when he made his decision. Now, my learned friend says that the judge didn't get as far as the third of Mr. Justice Farnhill's questions. We say he clearly did. What he did was to ask himself the question, what is the legitimate commercial interest which is protected by this default rate of 4% in this case? We say there's no other interpretation of paragraphs 205, and if I and put it this way, my Lord, Lord Justice Baker's paragraph 208 in the judgment, to which I'll return in a moment. Before I do that, my learned friend has another problem, which can I just mention in passing, which he didn't mention in the course of his submissions. In the core bundle, at page 45, you will find his respondent's notice. Behind tab 3. And you'll see that in the section at 45, where he says, where the respondent answers the question, what decision are you asking the appeal court to make? He's saying that the order at section 4 should be varied and the following order substituted. It is declared as follows, that the default interest rate under the facility agreement is not a penalty and is enforceable. Now, if what my learned friend is saying is, well, the judge didn't get as far as answering question 3, then it's hard to see how, with great respect, this court should be entitled to evaluate that issue itself for the first time, not having heard any of the evidence being given before this court. We would submit that even if my learned friend is successful in relation to this appeal, the correct approach for this court would be to remit the matter to the trial judge for him to evaluate the third question. The difficulty there, of course, as your lordship will immediately realise, is that that has a significant knock-on effect both on ground 1 of our appeal and indeed on the costs grounds. If, on the other hand, we are right that the learned judge did go on to question 3 and carry out an evaluation, then we rely on re B in terms of what this court's what is open to this court to do, and also on the case that my learned friend added, I think, to the authorities bundle, the re-sprint room case, which is at tab 17 in the authorities bundle. Can I just, rather than, in terms of view of the time, rather than taking you through that, just take you to the particular passages on which I rely and flag them.
They are quite commonly cited.
Yes, well, my lord, I won't spend a lot on it. The relevant passages start at paragraph 72 on page 596 and run through to paragraph 76.
And that's where you get the punchline, really.
That's where the punchline comes, and then I would also invite your lordship to look at paragraph 77 and 78, and in particular what Lord Justice Lewison says in Fage and Chobani about appellate courts not interfering with findings of fact unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. Can I now go back to the judge's judgment? At tab 9.1 of the core bundle. And the passage on penalty starts at page 128. And we say, first of all, that the judge correctly identified the test. I don't think actually, in the light of the answers that my learned friend gave to questioning yesterday, that that's now in issue. So at paragraph 198, he sets out what Lord Newberger says in MacDacey at 32, and then at paragraph 200, he sets out what Lord Hodge says. At paragraph 201, he refers to Hooja investments. I do briefly need to take you to that case, if I may, which is at tab 18 of the authorities bundle. and the relevant passages are at page 651. This is the decision of His Honour Judge Hodge, King's Counsel. We looked at this briefly yesterday at paragraph 144. But I just wanted to take you to the end of that paragraph 144, about 6 lines up. In the absence of any such evidence, in my judgment, the Hooja has discharged the burden of demonstrating that a 400% increase in the primary interest rate on default, when combined with a provision for monthly capitalisation of interest, is so obviously extravagant, exorbitant, and oppressive as to constitute a penalty. Whilst I would be prepared to accept without supporting evidence an increase of up to 200% in the applicable rate of interest on default to reflect the greater credit risk presented by a defaulting borrower, in my judgment, and as a rule of thumb, I would expect an evidential burden to pass to a lender to adduce evidence to justify any greater increase, at least where the lender enjoys additional personal and real security for its loan, as it did in this case. And that evidential passing of the burden is interesting, because in my respectful submission it perhaps explains to a certain extent why the learned judge in this case put it in the way that he did in his judgment. Indeed, in my submission he actually goes further than he needed to. He could simply have said, well, there's only that one paragraph in Mr. Theophanus's evidence, so there's no evidence before me as to what the legitimate commercial interest is that's protected by this default rate of 4% per annum. This default rate of 4%, 4% per month, this default rate of 4% per month, on the face of it, is a quadrupling of the standard rate, in line with what His Honour Judge Hodge says in Hooja. On the face of it, you might think that that's an exorbitant rate. So what I'm going to do now is to look for a legitimate commercial interest that it might be said that protects, because I haven't had that from the evidence. And that, we say, is the exercise that he then does in the paragraphs that follow. At paragraph 203, he says, and this is the second sentence, the question is whether the default rate protects the legitimate interest of LCL. In our submission, that is exactly the right question to be asking. Whether the default rate, that is to say this default rate, my learned friend says, well, that means a default rate. But he doesn't say a default rate, or whether or not default rates generally protect a legitimate interest. That's a given. We know it's a given because he mentions it at paragraph 201. The question is whether the default rate, in this case, protects a legitimate interest of LCL. So what he's doing there is he's answering question 2 and 3 together.
He asks it in 203, he asks 2 and 3 together.
Yes. Well, he asks 2 and 3 together, yes.
In 203.
In 203.
He asks 2 and 3 together.
Yes. Yes. And then goes on to seek to answer it in 204, 205 and following.
Yeah.
So we say not the best way of expressing it, but he did apply, we say, exactly the correct test. So firstly at, so I should mention 204, where he says charging a higher rate on default can be commercially justified on the basis of the enhanced credit risk. That's absolutely right. See Lord Mance. But it doesn't seem to me that this was the interest that LCL was seeking to protect by its 4% default rate. Certainly the case that Hussein's had credit issues. Mr. Theophanus, he then says, took all that into account when he fixed the standard rate, and that's right, he did.
Did Mr. Theophanus give evidence?
Yes, he did. And the evidence, I took your lordship to it
Yes.
a moment ago.
No, apart from the statement, did he give oral evidence?
Oh, yes, he did. He
And
did.
was he asked about the matters which you referred to? You said it's just confined to paragraph 15.
Let me ask my learned junior who was there. He says he was asked about it, but in the absence of the transcript, he can't exactly remember what the answers to the questions were, and we don't have the transcripts of that in the bundle. We do have the transcripts of the experts' evidence, which I'll take you to in a moment.
Well, so what he says about Mr. Theonophos' evidence in paragraph 205.
He's talking there about his evidence
Elsewhere
justifying the 1% per month standard
Yes.
rate.
And in fact, that's before repayment date,
Correct.
and isn't
default.
relevant
Right,
to
so
a default situation,
it's 206
and,
then, is it?
and an increased risk at all.
Yes.
It is. This is the rate that we put in relation to normal circumstances.
Yes.
Because of the risk in relation to these people and this circumstance.
There was a county court judgment.
Etc.
There was,
etc. But it doesn't address the issue which is relevant here, which is
Default.
how does it pick up after that, and how did you factor in
Yes.
the additional risk once there has been a default? And I say that I use default generally.
Yes.
That's a 206, is it?
Well, it's in the last 3 lines of 205. He says, I had no evidence on why late payment, so that's a default, even by a short period, justified an increase of a further 3% when 0.3 was sufficient to cover the historic credit risk factors.
Yes.
So he's there comparing the historic credit risk factors pre-default with the amount that you then add on for a default.
Is the
In trying to find whether or not, sorry, my lord, in trying to find whether or not that was the reason, that was the justification. He's actually, again, without repeating myself, going further than he needs to. He's trying to find some justification from the evidence for 4%, and the answer is he doesn't find any.
What about the even by a short period? Why is that relevant?
I'm not sure. As I say, it's not perfect.
Yeah.
And I don't seek to try and justify everything he said.
Mr. Theonophos' evidence
Yes.
as to the default rate
Yes.
is referred to in 206.
Yes. You're quite right.
And that,
my lord, you're quite right.
you could say that, I don't know. That might just be a summary of what he said at paragraph 15.
It may be. And again,
It doesn't look as though it takes it any further.
no. But the point is, in relation to 206, is that he takes into account the specific loan to value rate.
Yeah, the next paragraph.
Was the LCL loan was well secured. If the legitimate interest was a credit risk, one would expect some account to be taken of the security, but none was. In other words, if a standard rate is imposed, you're treating all defaulting borrowers the same, no matter what the default and the circumstances of the borrower. And that's despite the fact that the evidence showed that in fixing the standard rate, they took into account the circumstances of the particular borrower. Now, that doesn't, of course, mean that the default rate is necessarily a penalty, but the fact that no thought goes into applying a specific default rate, which reflects the specific risk in each case, is a factor which the judge is entitled, we say, to take into account in deciding whether this default rate is extravagant or excessive. And it's based on the evidence. I won't, I think, take you to it, but just maybe I will very quickly. In the supplementary bundle at page 246, so this is in the cross-examination of Mr. Griffiths, who's the appellant's expert. And the passage that I rely on for these purposes is between pages 141 and 142 of the transcript. So it's the two left-hand pages, starting at line 20 of page 141. Mr. Kiriakou and I were looking at the market as a whole, and what market defaults rate, and we are agreeing that 3% is more in line. but unless I heard the evidence of the last witness this morning, he said the contractual rate was dynamic, but that the default rate was not. I think that was the evidence of Mr. Theophanous. That's not necessarily my experience. I mean, I've seen quite a bit, and I would expect the default rate to be dynamic as well. So his evidence was that you can have, and indeed he has seen, instances where the default rate is dynamic, in the sense that it is tailored to the specific circumstances of the case.
What about the point he makes at the end of the answer about the application of the default rate will actually prevent the refinancing of the loan?
Yes, which again is a factor that anyone applying a default rate takes into account. He makes that point more than once, that, and it's in his expert report as well, and I'll take you to the references for that, is that if one factor is that if you're expecting the borrower to have an exit strategy which is refinancing, so some borrowers will have an exit strategy which is sale. They sell the property and then they repay. Other borrowers will have an exit strategy which is refinancing. So if you impose a default rate of something astronomical on that type of borrower, you're running the risk that they're not going to be able to refinance, because by the time they've defaulted, no one is going to come in and lend them that type of money in relation to that security. And that's the point that Mr. Griffiths is making. And the more general point he's making is, therefore, you look at the circumstances of the particular case to decide what the default rate is. We make the same point in relation to paragraph 207, albeit I accept it works to a lesser extent, that if the same default rate is applied whatever the default, that's a factor to be taken into account in determining whether the default rate is extravagant or excessive.
But those would be very unusual times, surely. If they specified,
They would.
This is the rate if it's this, and that's the rate if it's something else.
Yes. It would be unusual, I agree.
Very.
And then finally, and this is, as it were, I think the point where he is quite demonstrably answering question 3 of Mr. Justice Fancourt's questions, we come to paragraph 208, where he looks at the expert evidence as to what the default rate in the market ought to be. And I said I would take you to the relevant paragraphs. I'll just flag them rather than particularly reading them out at this point. But in Mr. Griffith's evidence at supplementary bundle at page 113, so that is behind tab
I'm sure we can find them.
9.1.
The tabs.
I'm sorry, my lord, yes.
Yep.
Paragraph 9, tab 9.1, page 113, and I would invite you for your note to note paragraphs 3.89 to 3.90, paragraph 3.94, and then at page 118, paragraphs 3.118, 3.120, and 3.125. And ultimately, Malone and Friends' submission, this is in his skeleton, and he repeated it in oral submissions, was that, if nothing else, none of the experts said that the rate charged was extravagant or extortionate, and that therefore the worst that could be said about it was that it was relatively high. And can I just take you back very briefly, before I finish, to the expert evidence cross-examination that we looked at a moment ago. Supplementary bundle, page 245. And this is where Mr. Griffiths is being cross-examined on the default rate. And it starts at page 245 on the right-hand side. At around on page 139 of the transcript, at around line 15. It's put to him that he says in his expert report that it's at the upper extremity of the band. And then on page 140, at line 2, you also agree, I think, and then he's taken to his report that lenders are reluctant to publicise their default rates. And then he gives an answer, and then at line 13, he says, but yes, there seemed to be more openness now from the lender index statistics, but 4% in my experience is very high. And then his cross-examination carries on, and then over the page, sorry, before we go over the page, he's asked whether or not he wants to be taken to his report. And at 23, he says, Mr. Kyriak and I were hovering around the 3%. The information he provided showed that the averages were actually lower than that. My rule of thumb is it should be twice the running rate, twice the standard rate, with a margin of error on either side. So if somebody is charging 0.65 or 0.67, I wouldn't expect the default rate to be 1.5. I would expect it to be a minimum. And I think the minimum comes in at about 2%, something like that. That's really fairly normal in residential lending, where the annual interest rate should be really quite low. And then he says this, for it to be 4 times the contractual rate, to me, is excessive. So
Sorry, where were you reading from now?
Sorry, my lady.
9, 10.
Page 141
Sorry,
of the transcript,
got it?
line 8 to 10.
Yes, I'm sorry, I jumped on.
That's all right. And then if you look at the answer, at the paragraph immediately underneath that, line 11, and of course the other point to make is that saying 4% a month is all well and good, but if you compound that, it becomes 60% per annum. It's a huge, huge penalty. So my learned friend says there was no evidence that the judge could rely on to say that this was excessive or exorbitant, and there was. We know that he preferred the evidence of Mr. Griffiths over the evidence of Mr. Kyriakou, because he says so in his judgment at page 94 of the core bundle.
And in fact, he goes on to explain why he was slightly departing from what he'd said in his report. Perhaps by what he said, he then says, line 20, the answer you've already referred to this answer
Exactly,
from another
yes.
point.
I took you to the next bit, and that's where he makes the point about the refinancing, because that was everyone knew in this case that was the exit strategy. So we say very clearly that there was material on which the judge could reach the finding that he then reaches at paragraph 209, that it was a penalty, based on the expert evidence that he's heard, and based on the lack of evidence that he heard about what is the legitimate commercial interest that this default rate was intended to protect. My lords, that's all I wanted to say, unless your lordships have any other questions for me. Can I just say something very, very brief about the
Interpretation. No?
Yes, about the construction question.
Yes.
Two points, really. Firstly, and I don't think this matters terribly much, but we do say that clause 6.61 goes beyond the repayment date because of the use of the words and or. Indeed, if my learned friend is right, you have a situation where something is not repaid on the correct date, which on the face of it falls within 6.61. But he says, no, you then ignore 6.61 and go to 12.5. And we say that can't be right. But the key point that I mentioned in reply to my learned friend's submissions is really the point that my Lord Justice Newey made to him, which is, would the person reading clause 12.5 understand that if 6.6 rate turned out to be a penalty, that would mean that they were paying 6.1? My learned friend's answer to that was, well, it's not unusual in a contract to have a fallback position To which my answer is yes, but normally that fallback position is understandable and express at the time that the contract is entered into. Here, the fallback position only arrives after a 1.5 year period and 6 days of litigation. And in my submission, it cannot be right that that is therefore the correct interpretation of 12.5. Even if I'm wrong about that, even if your lordships think I'm wrong about that, and the 6.1 rate remains, as it were, in there, then the words applicable mean what I say they mean. My learned friend didn't really come up with an argument as to why applicability or enforceability means applicability, other than simply saying, well, that's what it means. Well, that's all I wanted to say. I'm sorry I've run over my time.
No, that's very helpful. Thank you. Ms. Houssein.
Yes, my lord, I recognise the time. There's a few points that I do need to respond to. In relation to a question that my Lord Justice Baker asked yesterday about the
Would you give me 2 seconds just to tidy up?
Of course, sorry, yes.
Everything's going to fall
Absolutely.
on the floor.
Yeah.
Yes, I'm very sorry.
Not at all, my
Thank
lady.
you.
In relation to the question Lord Justice Baker asked yesterday about the offers and whether they were effective, in other words, whether they were beaten or not, we've had a look. Obviously, the offers that were made during the term of the loan are clearly effective and are accepted as effective.
Yes.
In terms of the 2 offers which were actually in the same terms made thereafter, so those are the offers made on the 14th of October 2021 and the 1st of November 2021 in the supplementary bundle at 316 and 318. Those offers we've had a look at, which were to pay the sums within a certain period, £700,000 on top of the 1.2 million that had already been paid, £700,000 within 28 days, and then a further £100,000 in 12 months' time. If we were to lose the cross appeal and they were entitled to default interest from the repayment date, so from August 2021, then those offers are still good offers. We've done better than that.
So if you lose the cross appeal and default rate is payable from August 21.
Yes. Then those 2 offers, which are in the same terms but are 17 days apart, those 2 offers are still effective. We've done better than that. In relation to the first offer on the 14th of October, the difference being, of course, that we were saying we would pay things within 28 days. So the 2 offers are slightly different calculations, even though they're the same principal sums. We've done better than that by £20,000. That's right. Sorry. Oh, we've done better by £80,000. And on the second offer, we've done better by 53,000 or 54,000 roughly pounds. So those offers are still, and if that was the outcome of the appeal, then those offers are still good offers. And I then revert to my previous submission. We're still the overall winners for the reasons I've said, and in terms of the discount from as a result of losing that discount would be, in our submission, would be relatively minor compared to the position otherwise. Can I just deal with the question of the judge's judgment in relation to outright winner? My learned friend says, "Oh well, you can't look at this as if it was a statute. Effectively, this is an extempore judgment, etc." We say that the fact that he's approached it in that way, that outright, which means comprehensive, complete winner, is demonstrated by him then giving up attempting to identify who the overall winner was. You go straight from that to just saying, right, you get your costs of the issues, each of you. And the point about that is that the whole structure of CPR 44.2 requires you to start by identifying the overall winner. That then gives you your default position that the overall winner gets 100% of their costs, and then you have to decide whether to depart from that, and if so, how far to depart from that. And that's where we say Malone Friend goes wrong when he says, oh, well, you've got your costs of the issues you've won on, so where's the unfairness? No, it's a very different thing, and it goes back to his submission. If you were with me on this point, that there shouldn't have been an issue-based cost order, then you tot up what my issues are worth and you tot up what his issues are worth. You come to 60, 40, therefore 20%. No, we say that's fundamentally wrong, because we're the winner and we start with 100%. And you have to then decide how much to depart from that. And quite apart from that, of course, his formulation ignores the offers entirely, because he's just working out how much was spent on each issue and putting it in percentages. So that's a fundamental difference, and it goes back to the point that my Lord Justice Newey made about the letter, about the litigation. You start off with 100% for us, and you decide, oh, well, actually, it was, some of that was spent on undue influence, so we'll discount from that. It's a very different position from you start afresh, you look at that letter and you go, right, how much was undue influence, how much was this, and you divide it all up. That's what he submits. And we say that's not in accordance with CPR 44.2. Yes, unusually, you can come to the decision that there is no overall winner, but the judge hasn't done that exercise, and it wouldn't be right if he had done that exercise, quite clearly, because what was this litigation all about? This litigation came about because of the allegation of event of default, which they have lost on. In relation to, so my learned friend, in my submission, somewhat makes our point for us when he says that the appellants could have advanced their case in a more restricted manner and been successful. Yes, we say that's absolutely right. We could have done, but that demonstrates the fact that we had at our core a good case which has been successful. We added on these other things which we lost on, and we have to suffer some consequences for that. But the core of the case that we brought had to be brought in order to protect the family home, and was successful. My learned friend made a point about the fact that the judge deals with the sham issue first, and I just adopt my Lord Justice Baker's point, which is absolutely right, was that logically sham comes first. In terms of chronology, it comes first. It was first, I'm told, in both the trial skeletons. Doesn't mean it was the most important issue, it just has to be dealt with first, because if an allegation is made that the whole thing is a sham, you don't even get to the 29th of July inspection, etc. The correct analysis, we say, and my learned friend doesn't really grapple with this, is if you start from the position that we're the overall winner, then how much extra time was spent on sham, undue influence and consumer matters? And he doesn't identify that evidence because it is in reality very limited. And this feeds into the point about paragraph 189 of the judgment. I won't ask you to look it up now, but that's where the judge says, well, the breach issue or the event of default issue potentially involved numerous issues. In the end, only one was relevant. But you don't get to that without analysing exactly what's happened up to that point. If you're looking to see who knew what when, you don't just look at the 29th of July in isolation. You've got to look at the previous meeting, the emails, all that. So all that is relevant as to who knew what on the 29th of July. In relation to the offers, and in relation to escaping all liability, we accept that if we'd won on the sham or undue influence argument, that we clearly were liable to repay the loan amount. We can't escape that. It's I imagine unjust enrichment, etc., we'd have to pay that back. We accept that enforcement falls away. The security falls away, so enforcement becomes more difficult. But enforcement doesn't become impossible because the structure of the loan was that the loan was made to the company, and the company then gave the money to Mr. and Mrs. Houssein. So presumably you wind up the company, and you then pursue Mr. and Mrs. Houssein, and the most obvious route to get their money is through the property. But we accept it's more difficult. That's clearly right. But it wasn't an escaping all liability. My learned friend raises the case of Capelli, which is at tab 15. Don't ask you to look it up now. As to the test of who pays the cheque identifies who is the winner. I mean, we've got 2 points about that. Firstly, it's not his best example because in Capelli, the trial judge, Mrs. Justice Whipple, applied that test in a group action where a small number of the claims had been successful. And she said, well, the starting point is the claimants have been successful, therefore, and she said that they should get 33% of their costs. Lord Justice Hickenbottom and the Court of Appeal said she was wrong for identifying that as the test in that case. And that demonstrates that who pays the cheque is not always the answer. Can give you the answer in certain types of cases, but in this case, we clearly had to repay the loan. So there was clearly going to be a cheque written by us. So it doesn't really help to analyse it in those circumstances. We never suggested that we weren't. That is, on the facts of this case, a meaningless test. And in relation to the offers made, my learned friend says, well, we haven't got all the responses in the bundle, and we made offers as well. Well, they could have put their offers in the bundle if they wanted to. We sent them the index. It was up to them whether they wanted to put them in. And of course, if they bettered them, and he doesn't suggest they did, you can bet your bottom dollar they would have been in. And he says, well, they're not that far apart. But the point about that is, and you know, there was at one time a decision of the Court of Appeal called Carver and BAA, where you had a near-miss principle. If you'd made a Part 36 offer, you didn't quite beat it, but you were very, very close, then you know, that was taken into account. And the rules changed to get rid of the near-miss principle. You either beat an offer or you don't beat an offer. And it's as simple as that. It's black and white. And they didn't beat their offers. And the reason they didn't beat their offers is because they wanted all or nearly all their default interest from the event of default, as they alleged it, namely the occupation. So throughout, or from the demand notice. And that was the sticking point throughout, was that they wanted to hang on to that event of default being the residence, the occupation of the property.
Which you say is the principal issue you won on.
Exactly. They lost on it. And my learned friend's answer to that is, oh, well, we bear the costs of that because we have to bear the costs of appointing the receivers, etc. Well, that doesn't get to the heart of it. The point is, if they'd accepted those offers, the entire litigation would never have happened. So just because they don't recover the costs of appointing the receivers is really nothing to the point. They should have accepted those offers, in which case the case would have settled, in which case none of these costs would have been incurred. Indeed, we wouldn't be here today. My learned friend makes a number of times, he says, we could have, my clients could have repaid the loan on the repayment date. The difficulty is, and the reason why that hasn't been done, is because we need the properties to be released from their security in order to do that. And the respondent's position has been, we're not releasing the security because of the default interest claim. So it's not a fair point to say to us, oh, well, you could have paid off the money. Yes, we can only pay off the money if the security is released, and they won't release the security. The security remains on 71 Hamilton Road and on 205 and 207 Downhills Way. So that isn't a fair point. Then, in relation to the way the judge went about the issue-based cost order, the fact that he didn't raise it at all before, he simply just gave judgment and whether that was a serious irregularity. My learned friend says, well, it's common where one side is one extreme and the other side is the other extreme, and the judge comes somewhere down the middle. And of course that is right, but that's not what happened here. This is a different order in kind to either party, what either party was asking for. Both parties were asking in relation to costs for percentages, and the judge has come down with a completely different order in kind. And we say that goes about it in the wrong way. In relation to indemnity costs, essentially what we say is that it is unreasonable to a high degree in attempting to, in effect, from my client's point of view, put the family home up for sale because they were occupying the family home. It is unreasonable in those circumstances to refuse repeated settlement offers. And the reason they refused those was because we didn't pay enough default interest, which was based on the event of default when you are fixed on their side with your officer's, Mr. Stylianidis' knowledge that you are not entitled to it because he waived it. We say that is unreasonable to a high degree, and that combines the basis of the entire claim, the basis of the entire allegation of event of default with the refusal to accept the offers. Unless the court has any further.
Thank you very much. Mr. Wheeler, I'm hopeful you won't be all that long.
I won't.
Good.
Mindful of the time, my Lord. I'm very
Excellent.
much mindful of the time. I'm grateful for the court's indulgence. My learned friend's first answer on major point on penalties was to say that the judge essentially grappled with stages 2 and 3 of the inquiry together. And in my submission, if that is what he did, he must have fallen into error, because stages 2 and 3 demand entirely separate inquiries. They're very different questions, and one can't just lump them together and answer them in one go. Stage 2 is the legitimate interest question. My submission is that's very straightforward. Stage 3 is an entirely different point. Not is there a legitimate interest, is this particular rate extortionate? So you have to separate them out. As far as White and Davenham is concerned, in my submission that doesn't take matters further, because it simply finds that on those particular facts of that case, the issue was arguable. And that's really all it decides. In terms of whether this should be remitted to the judge, my submission that would be disproportionate and unnecessary. This court has ample materials available to it and can decide. It's not. There's no basis. There was no finding that the rate was extortionate, and there was no basis for a finding that the rate was extortionate. And once one focuses on the correct question, in my submission, it becomes very straightforward. And my learned friend on that point took the court to the evidence in the supplemental bundle and the transcript and the expert evidence, and I won't go back to it, but it's at page 246. What he didn't go on was to the next section, using the internal pagination of the transcript, page 142, bottom of 246, where at lines 14 to 17.
I'm sorry, you just have to wait a moment.
I apologise,
Okay.
page 246.
Yes. And then?
On the left hand, page 142 in the internal transcript number is bottom left hand side. Lines 14 to 17. It was said it's a high rate. I think we all accept that, but there's nothing extravagant or unconscionable about it. So here, as it were, stage 3 of the Cavendish test is put directly. And the response is not, yes, it was. The response is, well, I find the 5% difficult. And that reference to 5% rather than 4% isn't an error. It's because of a rather convoluted argument that was raised by the appellant's expert and was alluded to at trial, not accepted by the judge. So this court hasn't really been troubled by it. But effectively, the argument was to the effect that, well, the default rate isn't really 4%, even though that's what the contract says. In substance, it was 5%, because you're applying interest to interest. And I don't entirely follow the argument. But the fact of the matter is, in my submission, the rate is 4%. That's what it says it is. And the expert wasn't prepared to say, well, yes, 4% is extravagant. He sort of slightly dodges the point and goes on to a different rate, the 5% rate, and says, well, that rate was difficult, to use his word. So it's not quite as straightforward as my learned friend suggests, striking though the passages that he took the court to earlier. The evidence is not as clear-cut as on the point as...
Well, the answer goes on page 143, doesn't it?
It does, and that's where he tries to explain this 5% point and where he gets it from, rather overlooking the fact that basically the interest paid at the outset is capitalised. That becomes part of the principle. If any further interest is applied, well, of course it's applied to the whole principle, and it's applied at the rate of 4%.
And he goes back to the point, line 24 on 143, that it's going to kill refinancing stone dead.
Well, that's, of course, my learned friend's other point.
Yeah.
He says, well, this default rate stops refinancing. But in my submission, it's not really the default rate that's stopping refinancing. The first hurdle to refinancing is the default itself. And of course, if your route out of the loan is refinancing, if you fall into default, that is inevitably going to change the route by which one can refinance. It inevitably makes it harder. And that, of course, is precisely why the sort of protection that a default rate provides is necessary. And then the final point that my learned friend raised that I need to respond on is when he referred to the evidence of Mr. Theophanes. And he said, well, just shows that effectively it was set as a standard rate based on market rates. And the gist of the submission was, well, that's really not sufficient rationalisation. But in my submission, to simply set the rate on the basis of, well, this is where the market is at, that's what we think where we should be too, that in my submission is a perfectly adequate explanation for the rate. And it doesn't begin to follow from that rationale that the rate is extortionate. It's simply a non sequitur to suggest that, well, because it's set as a standard rate based on where the market is, that therefore it's extortionate. One only has to state that proposition to understand it simply cannot be correct. Well, may I just have a moment? Unless my lord has any further questions, or my lady has any further questions.
No. So thank you very much, Mr. Wheeler. Thank you all very much for your very helpful submissions, and also for getting us through virtually on time, because it's no fault of your own that you lost a quarter of an hour, and so we would have finished more or less at 1 o'clock. So that's all very helpful. As you'd expect, we won't give a judgment now. Before the judgment is handed down, which nowadays, of course, is electronically rather than in a courtroom, you will in a normal way be supplied with the judgment in draft for you to correct our typing in English, but not, of course, to re-argue the case. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. Finally, and I know you will all have this well in mind, I should reiterate the importance of complying with the embargo. I know that we've been supplied already with a list of intended recipients for the draft judgment. If there proves to be anyone else who you would wish to see the judgment in draft, you must, as you know, get permission from us before that happens. But thank you again. Thank you. We'll wait and see
Yeah.
where we end up.
Yeah.